Okay, everybody. In this lecture, we're going to talk a little bit about Nixon and his views on civil liberties and some of his violations of civil rights. This comes out of the chapter 11 in the Rees book. And also, we're going to be looking at chapter 13 in the Irony book. All right, so we're going to be talking about civil rights. We're going to be talking a little bit about the Patriot Act, which, as you all know, we have our May 1st paper due, and it's a question regarding the Patriot Act, okay? So, a couple of things. When we talk about Nixon, Nixon was kind of a gruff individual. Coming out of, um, the passage of the civil rights movement and out of LBJ's fight to kind of continue Kennedy's legacy with the Civil Rights Act, Nixon kind of seemed both for and against the civil rights movement. One of the first goals that he had was to impose racial equality within his administration. He approved what was called the Philadelphia Plan that required contractors to bid on federal projects and make a good faith effort to try and hire minorities as part of that workforce. However, Nixon also kind of followed the Southern strategy where he was catering to white voters in the South by attempting to slow down desegregation of the schools. But on the other hand, he also encouraged the EEOC, or the Equal Employment Opportunity Commission, to force private employers to accept hiring of minorities and women. So, you could see Nixon was a little bit for and against civil rights. Nixon also chose to adopt a policy based on a unitary school system. However, in order to avoid that controversial issue of busing, he favored on the basis where children, without taking account in race, would attend school to the closest to their residence, which really happens right now. Um, Nixon also pursued the strategy of black capitalism, which increased employment opportunities for blacks. He also implemented Executive Order 11458. And as we know, executive orders have the weight as laws, much like a law that Congress passed. But this is more a directive from the president to the bureaucracy to carry out a goal or a law. He established out of this executive order the Office of Minority Business Enterprise, which expanded the federal look for firms owned by African Americans and gave them, contracts that dealt with the government. Some of the other actions that were relevant today are the Controlled Substance Act that Nixon signed into law in 1970. The CSA, along with, the Food and Drug Administration and the DEA, scheduled drugs according to 5 different schedules based on their medical application and potential for abuse. Scheduled 1 drugs, which are controlled substances, and if you don't have a prescription for them, or if it's an illicit drug, you could pretty much be facing some jail time. So we look at here, Scheduled 1 drugs involve heroin, LSD, cannabis, and ecstasy, right? So it's kind of obvious too when you see that, some of the screwiness out of this Controlled Substance Act, that cannabis and heroin are on the same schedule, right? Now, if you look at Schedule 2, you have your opiates and your cocaine. Cocaine is considered a Schedule 2 drug because it does have some medicinal purposes for it. Opiates, as we all know, the opiate problem that exists here in the United States with pain medication and things like OxyContin and Vicodin are Schedule 2 drugs, meaning you need a prescription to be able to take that drug, and the doctor has to limit it. And there's a bunch of different things that come into that we're really not going to get into. But when you hear the schedules, this is what they're talking about. Schedule 3 are your steroids or your Tylenol with codeine. Now, when we're talking about steroids, we're not necessarily talking about performance-enhancing drugs. You can take a steroid if you have asthma for as an inhaler. You can use steroid cream for any type of maybe psoriasis or skin affliction that you have. So it's not necessarily performance-enhancing drugs. And then our Schedule 4, which are your Xanax, which is an anti-anxiety medication. Valium, same thing. Ambien, which is a insomnia medication. Tramadol. Those are Schedule 4 drugs. And then we have Schedule 5 drugs that are antidiarrheal, antitussive, which means anti-cough, and angiocytic purposes, meaning pain relief. Nixon, along with the DEA and the FDA, instituted these these schedules. And as we know, as part of Nixon's War on Drugs initiative, we started to see mandatory prison sentencing for drug crimes that kind of affects us still today. Nixon also kind of violated civil liberties by running a program called COINTELPRO, or the Counterintelligence Program. It was kind of a series of events that were covert and at times illegal, where the FBI was surveilling, infiltrating, discrediting, and trying to dig up dirt on domestic political organizations. In March 8th of 1971, an anti-war group called the Citizens Commission to Investigate the FBI broke into an FBI office in Pennsylvania and discovered a cache of classified documents titled COINTELPRO. Beginning in 1969, leaders of the Black Panthers were targeted under COINTELPRO. Some of them were murdered, assassinated, imprisoned. They were also kind of caused to fight with each other, right? So some of the Black Panthers affected were Fred Hampton, Mark Clark, Zayad Shakur, who is no relation to Tupac, Geronimo Pratt, and Mumia Abdul-Jabbar, two individuals that are still in prison today. If you want to learn about some interesting kind of stories, those two have some compelling stories, and you know, there's been some arguments, especially with Mumia Abdul-Jabbar, who was kind of accused and convicted of killing a police officer in Philadelphia. Some people are questioning the validity of his conviction. Among them are the group Rage Against the Machine, who are a really outspoken advocate for his release. So if you are interested in reading about some of that stuff, he's a compelling figure to look at. COINTELPRO also encompassed the Socialist Workers' Party, which is a funny name when you think about it, because what was the original Socialist Workers' Party? Isn't it the Nazis? The Klan, the Nation of Islam, the Black Panther Party, leftist groups, anti-war groups were all being investigated by the government. What they would do is they would create a negative image for these groups and have the public turn against them. Then they would also kind of infiltrate the internal organizations by creating conflicts between leaders, which would exacerbate tensions and try to create conflict. They would create dissension between groups by spreading rumors, restrict access to public resources by pressuring nonprofit organizations to cut off funding, and to restrict the ability to organize protests through agents promoting violence against police during planning and of protests. And they also restricted the ability of individuals to participate in group activities by, making assassinations of their character or arresting them or surveilling on them illegally. Nixon also authorized wiretaps, which produced for the White House purely political purposes. Information unrelated to national security, including information about a Supreme Court judge.
The report identified Black identity extremists as a threat to law enforcement. Critics say the report is eerily similar to the FBI's 20th century counterintelligence program.
COINTELPRO was an FBI operation established in the 50s by J. Edgar Hoover to target African Americans who were fighting for justice and equality. He targeted Dr. King, he targeted Malcolm X, and over 80% of the targets of COINTELPRO were members of the Black Panther Party.
At the height of COINTELPRO, activists and community organizers were targeted. These include current Congressional Black Caucus members like John Lewis, Bobby Rush, Emmanuel Cleaver, and Barbara Lee.
The Church Committee in the mid-70s held hearings and determined that many of the actions and activities of COINTELPRO were really unconstitutional.
What you've described is a series of illegal actions intended squarely to deny First Amendment rights to some Americans. How shall we ensure that it never happen again?
One of the similarities that I see are that it's based on race. COINTELPRO definitely targeted African Americans, Black identity extremists, which Attorney General Jeff Sessions has put out, targets African Americans. When it was brought to our attention, we immediately contacted the FBI director and had a very forthright meeting. I specifically asked him, how do they identify Black identity extremists? Who are they? And there was no answer to that. We still don't know who's a Black identity extremist.
A lot of activists around the country are very concerned that we're getting ready to repeat a very sad chapter of our history, where people who are rightfully protesting what they consider to be an injustice in their community, which is their relationship with police officers, are now being targeted and labeled as extremists and are going through periods of surveillance and harassment.
As a community worker, I attended many Black Panther Party functions. I was part of the breakfast program. We registered many people, the African American community and others, to vote. Well, the FBI during COINTELPRO would try to turn members of the Black Panther Party against each other. Agent provocateurs were placed within the party to try to sow dissent.
I was the coordinator of the Illinois chapter of the Black Panther Party. In December 4th, 1969, Fred Hampton and Mark Clark, two members of the Black Panther Party, were murdered. And they put an informant, William O'Neill, planted him inside the Panther Party.
We can mourn today, but if we understood, Fred, that we are dedicated, that his life wasn't given in vain.
The National Director of the FBI said that the Black Panther Party was the #1 threat to national security of this nation. And that created the condition for law enforcement agents all across this nation to go after Panthers. That program that they did, in some sense, we ought to be thankful for, because that put in writing for everybody to see we're still in the eyes of so many, nothing but a bunch of work. Was I surprised? No. I fully expected it to happen. Now the question is, how do we deal with it?
People need to get to their members of Congress and get them a copy of this report and hold their members of Congress accountable. In this day and time, they could really stop and halt the progressive movements that are taking place in the country. And I think with Black Lives Matter, with the Dreamers, with all of our millennials and what they're doing, they deserve to be out there and to protest and to engage in petitioning their government to right the wrongs of the past. Those of us who've been around, who saw COINTELPRO, really know the risks and the dangers. And so I hope that people really believe us that this happened, because this is COINTELPRO 2.0.
One thing that we're going to notice throughout history is that anytime there's some type of conflict or there's some type of interesting event, and we could even tie it into the COVID-19 virus, that at times the government's going to try to minimize or try to in a sense roll back some of our civil liberties, whether it's a catastrophic event, a natural disaster, or a terrorist attack. If we look at this, one of the first things that happened was in response to the threat of the French in 1789, President John Adams instituted the Alien and Sedition Act, which made it easier to deport immigrants and restrict the right to vote. You could be fined or imprisoned for publishing anything that was written, printed, uttered, or published any false, scandalous, malicious writing against the government. Now, we're not to 1791 yet, so we don't have the First Amendment, but you can definitely see when we have the First Amendment, this is kind of conflicting with it, right? During the Civil War, Lincoln, who's been one of the more beloved presidents here, suspended the habeas corpus, which is, habeas corpus is Latin for release the body, meaning that if you're detained by the government and you're not charged and ran through that due process system, a lawyer can institute what's called a writ of habeas corpus and get you out of detainment. Nixon suspended this at that time, and he was federally able to do that through the suspension clause, Article 1, Section 9, Clause 2 of the Constitution. World War I, we had the Espionage Act, which made it a crime for any person to convey information intended to interfere with the U.S. Armed Forces prosecution of the war. And it was intended to prohibit with military option or recruitment to prevent kind of insubordination in the military and to prevent the support of U.S. enemies during wartime. So it'd kind of be like illegal, much like now if we would harbor an enemy. It's like the Palmer raids. The Palmer raids were a series of raids that were conducted by the U.S. DOJ, the U.S. Department of Justice, during the presidency of Woodrow Wilson. The goal was to capture suspected leftists, anarchists, and deport them from the U.S. It kind of evolved out of a speech made by Wilson in 1915, when Wilson warned against hyphenated Americans who he charged had poured the poison of disloyalty into the very arteries of our national life. Such creatures of passion, disloyal, and anarchy must be crushed out. We also had the Sedition Act of 1918, which made it an offense to, notably among speech and expression of opinion that casts the government or the war effort in a negative light or interfere with the sale of government bonds. Now, criticizing the government here, First Amendment violation seems to be so, right? Then we have World War II, right? Executive Order 9066. 110 to 120,000 people of Japanese ancestry were put into internment camps. Was this a violation of the Fifth Amendment and the 14th Amendment? I believe so. Out of this came a court case called Korematsu versus the United States. Freddie Korematsu asked the Supreme Court of the U.S. to hear his case. Mr. Korematsu was detained as in an internment camp. When his case was heard, the Supreme Court in a 6-3 decision felt that detainment of Japanese Americans was based off of a military necessity, not so much based off of race, which was kind of ironic because you had more Nazi and Italian sympathizers in New York City than you had Japanese Americans on the West Coast. So, I do not believe or by that it was not based on race. Then we have something called the Patriot Act, right? And the Patriot Act is a controversial act, and we're going to discuss a little bit of it. Okay, so let's start up, talk about the Patriot Act. So the Patriot Act was passed in response to 9/11. Stands for the unity and strengthening of America, providing appropriate tools required to intercept and obstruct terrorism. So the USA Patriot Act was passed on October 26, 2001. This is a copy of the act. And one thing that we need to know about the act is that the act is, around 300 to 400 pages. On October 23rd, Representative Jim Sensenbrenner introduced the bill. On October 24th, that bill was passed in the House 357 to 66, with Democrats comprising the overwhelming portion of dissent. On October 25th, the act was passed by the Senate 98 to 1, and then it was subsequently signed by the President on October 26th. My main concern about this act is it gives away a lot of our civil liberties, and also look at the quickness that it was passed in. It was originally, passed in response to 9/11, a very large act that was introduced on October 23rd and then eventually signed on October 26th. I mean, look how quickly this piece of legislation went through. Some of the things that are important about the Patriot Act are Section 215, which sanctions the seizure of anything tangible without warrant that the government has reason to believe is affiliated with an act of terrorism. So these tangible things can be books, records, papers, documents, your orders on Amazon, right? So the government can look in these without, if they believe anything is a tangible item that might aid in terrorism, they can look at it. That includes, like I said, books, reading revolutionary books. That's another thing. So if you read Common Sense, you might be flagged. Just, kind of a thought about that. Okay, Section 206 permits roving John Doe wiretaps, meaning the governments can surveil and wiretap of a specific person without a warrant. So, putting bugs on your phones or putting microphones in your office. If you're considered to be engaging in a potential act of terror, which is already kind of a broad scope definition anyways, the government can surveil against you. Section 6001, or the lone wolf provision, authorize secret surveillance of non-U.S. citizens who give the government reason to believe he or she will participate in an act in international terrorism. Now, some of the questions of this is some of the broadness in the definitions that, what do we consider to be a terrorist? What do we consider to be a terrorist act, right? One of the things that is kind of interesting about this is the government has the power to go through your financial records, your medical history, your internet usage, your bookstore purchases, library travel, or anything that leaves a record if they consider you to potentially be a terror suspect. I think that's one of the key things, one of the interesting things when you say, what's the problem with the Patriot Act? It seems like it's used to try to fight terror, but then the government can maybe frame it in a way that, they can use any of it as an excuse to maybe surveil on anybody. Now, we're going to look at some important Supreme Court cases, right? And these are good cases that if you want to look at and use for your Supreme Court paper, by all means. Hamdi versus Rumsfeld. This is a Fifth Amendment case. Hamdi was an American citizen. He was detained by the U.S. military in Afghanistan. He was born in New Orleans, and then he moved to Afghanistan at the age of 1 and joined the Taliban, right? He was accused of fighting the Taliban and declared an enemy combatant and was held in Guantanamo Bay. It was argued that the government had violated Hamdi's Fifth Amendment rights to due process by holding him indefinitely and not giving him access to a trial or an attorney. The government basically said that the executive branch had a right during wartime to declare people who fight against the United States as enemy combatants, and thus they can restrict their court access or the court system or their right to due process. Basically, what the court found was that they agreed that the executive branch doesn't have the power to hold a U.S. citizen indefinitely without due process, but they can extend that to people that are non-U.S. citizens. So basically, if you're a U.S. citizen, you're always going to be entitled to due process, even if you're considered to be an enemy combatant. But if you're a non-U.S. citizen or an illegal or a permanent resident or whatever, they can detain you without due process of law. Now, when we talk about freedom of expression, Gitlow versus New York is an interesting one. Gitlow was a socialist who was arrested for distributing copies of a left-wing manifesto. He advocated the establishment of socialism through strikes and class action, or collective action. He was convicted under a state criminal anarchy law and was punished advocating overthrow of the government by force. This comes to the point where when do we have free speech and when we don't? Obviously, we can't be arrested for anything that we say, but there are standards that if our statements create what's called a clear and present danger, then we can be arrested for it, right? So if we say something that might create a social disturbance, like right now is not a good example, but if I go into a crowded movie theater and yell fire, right? I can do that, that's fine, but I might face a consequence because that creates a clear and present danger. Or if I go to the airport and yell bomb, right, I'm able to do that, but, there's consequences if you do that. Miller versus California is another interesting case. Miller was sending pornographic material through the mail, and he was arrested for it. Some unwilling recipients of Miller's brochures complained to the police. So there is some concerning things about, art and pornography and kind of the fine line through it. If something is to be considered obscene, it has to pass kind of these three-tiered tests that we have. Would it offend the average person using community standards? Right? If it does offend the average person using basic community standards, then it could possibly be obscene. is the work in question illegal? So pornography involving adults is legal to a certain extent, but if there's something that's illegal, like the use of children or something like that, and it's against the law, then it's considered to be obscene. So child porn would not be protected by the Constitution. And lastly, is the work taken as a whole, does it lack serious literary, artistic, political, or scientific value? So if that happens, and if you meet all these standards, then something can be considered to be obscene. Lemon versus Kurtzman basically says that, is it illegal for states to provide funding for non-public, non-secular schools? Does that violate the First Amendment? Yes. The statute must have a secular legislative purpose, so the government can't give religious-based private schools public monies because it's a violation of the Establishment Clause of the First. Okay, one of the things that overturned Lemon was this recent case called Kennedy versus Bremerton School District. And what happened was it established that while following the Establishment Clause, school districts cannot suppress an individual from engaging in a personal religious observation, as doing so would violate the free speech and free exercise clause of the First Amendment. So what would happen is a football coach would lead a prayer after a game. Therefore, individuals are in the right to do so as an expression of their religious freedom. There were some controversies attached to it. I mean, the other side was afraid that maybe if they didn't follow along, their playing time might be limited. So that's kind of where this whole controversy started and how it ended. In it overturned pieces of Lemon, but also gave people the ability to express maybe a meditation or a prayer after a game or in school.
Hello from the Federal Judicial Center. I'm Beth Wiggins, Director of the Research Division, and this is Term Talk. In each 8 to 12 minute episode, we discuss what the lower courts may need to know about this term's decisions. Joining me today is Erwin Chemerinsky, Dean, and Jesse H. Chipper, Distinguished Professor of Law, University of California, Berkeley School of Law. Also here is Michael McConnell, former judge for the 10th Circuit Court of Appeals, and now Richard Francis Mallory, Professor of Law and Director of the Constitutional Law Center at Stanford University Law School. Thank you both for being here. Today we're discussing cases implicating the First Amendment religion clauses. So Erwin, let's start with Kennedy versus Bremerton School District, which of course involves school prayer. Can you explain the facts and issues in this case?
Sure, I want to start by putting this in context. Since the early 1960s, the Supreme Court has said that prayer in public schools, even voluntary school prayer, violates the Establishment Clause. The Supreme Court has been very strict in a number of cases, in many contexts, in saying that school prayer violates the First Amendment. Well, this case is about school prayer. It involves a high school football coach, Joseph Kennedy, in Bremerton, Washington. There's a major dispute as to the facts between the majority opinion and the dissenting opinion, but I think both would agree that Joseph Kennedy would go onto the football field after games, kneel at the 50-yard line, and do a silent prayer. He said this was because he was a devout Christian. Sometimes players from his team or the other team would join him. There was a complaint from a parent. The parent said that his son was an atheist and felt he wouldn't get as much playing time unless he participated in the prayers. The school system asked him to stop this. He briefly ceased, But then he began the practice of going onto midfield after games and delivering an inspirational Christian message. Sometimes players from one team or both would join him. Occasionally, people from the stands would join him. He was suspended. He was given a poor performance evaluation. He sued and said that the discipline violated his First Amendment rights to freedom of speech and free exercise of religion. The lower courts ruled in favor of the school district, emphasizing the First Amendment prohibition of school prayer. The United States Supreme Court, in a 6-3 decision reversed, ruled in favor of Kennedy, saying the discipline did violate both his free speech and his free exercise of religion.
So, Michael, how did the court come to that determination?
Well, as Irwin said, the facts here make a great deal of difference. And to read the dissent and the majority, you would think you're reading two different cases, because the majority emphasizes the change that had taken place. Coach Kennedy did a lot of things in the past, but he had agreed that he would not have any religious content in his inspirational messages. He agreed that he would wait until the team was not even there, so they wouldn't even see his silent prayer on the field. And when you get down to that point, I actually think it's a bit of a surprise that the court case didn't settle. But then to read the dissent, they emphasize the things that he used to do and make him out to be someone who is really trying to coerce and influence the members of the team. Now, from the point of view of lower courts, what matters isn't what the facts were of this case. What matters is what are the rules for evaluating similar cases. And the real question here is whether when he was engaging in these prayers, Coach Kennedy was speaking with the authority of the school, as opposed to this being one of the occasions when a private speaker, even a government official, even a teacher, can sometimes engage in religious activities on school premises, but where they're not actually speaking for the school. And I think that's ultimately the key distinction here. And I don't think that's a particular departure from past cases, although perhaps the court was more sympathetic to the context than it has been in some past cases.
Okay. So, Irwin, you mentioned the dissent and how the facts somewhat differed. What did the dissent say?
It was a vehement dissent written by Justice Sotomayor. She disagreed with the majority's characterization of the facts. She said this was not a private moment. It was not after the school event was over. She included pictures in her dissent to show the football coach was surrounded by players from both teams, and she said it was still part of the football event. She said this was a major departure from precedent because the prior 60 years of decisions had all prohibited prayer in schools. The dissent said that the majority ignored the evidence of coercion that was in the record. The majority said, contrary to Justice Gorsuch's assertion, the Lemon Test never has been overruled. And the dissent objected to this idea of a test based on history and tradition, looking to 1791, saying that gives almost no guidance to the lower courts.
Well, so Michael, what do you think this is likely to mean for the lower courts?
Well, I do think it's a little peculiar for Justice Gorsuch to say that the Supreme Court had long abandoned the Lemon Test when it has never actually uttered the magic words, the Lemon Test is overruled. But I think that is the meaning of this case. I think for lower courts going forward, they should assume that the Lemon Test is no longer the operative principle.
I want to focus on that. I agree with Michael that though the court had never before overruled Lemon, that's the practical effect of this decision. But what is that going to mean? There are many Supreme Court cases that were decided based on the Lemon Test. Are these still binding on the lower courts? Have they been implicitly overruled? And what's it going to mean in terms of prayer in schools? It's not just here that the Supreme Court said that the school may allow the prayer. The court's saying the Free Exercise Clause requires that the school permit the prayer. At the very least, I think this says that when there is, to use Justice Alito's words, a lull in the activity, before school, recess, lunch, when children have their heads down on the desk after school, teachers are allowed to pray in the school classrooms. And if students join them, that doesn't violate the Constitution.
Okay. Well, thank you both for being here today, and I look forward to talking with you again.
First Amendment. Now we have a Fourth Amendment question. Mapp versus Ohio. Dollery Mapp was suspected of hiding a person who was accused of a bombing in Cleveland, Ohio. They knocked on her door and demanded entrance, but Mapp refused because they did not have a warrant. When they searched Mapp's house without a warrant, they found pornographic material. They arrested Mapp based off of an Ohio law against the possession of obscene material. The court determined that the evidence obtained through a search violated the Fourth Amendment and is inadmissible in state court. So what this establishes what's called the exclusionary rule, right? The exclusionary rule basically says that if the police do not have a proper warrant in the search of a home or the search of a person or the search of property, then that evidence can be excluded from trial. Now, are there certain provisions to that? If you are driving a car and speeding and the car smells like marijuana smoke or alcohol or whatever, that gives the police officer the reason to believe that another crime is being committed, so they have the right to search. If they see something that's in plain view, they have the right to search. Right? So if you're driving and you're speeding and they see a gun on your passenger seat, it's illegal, so they have a right to search. If you're running, if the police tell you to stop and you run, or you run in a car, or you drive off, they have a right to search you then because you're in flight. Gideon versus Wainwright is one of the more interesting cases. What Gideon versus Wainwright basically says that anytime we're charged with a crime, no matter what the crime is, we're entitled to an attorney, right? And remember, and I really want to stress this only has to do with criminal cases. So Gideon was a felon who had broke into a pool room with the intent to commit a misdemeanor offense. He requested a lawyer. However, at that time, Florida law only said you could have a lawyer if you're facing a capital case, or capital case is a death penalty case or a life in prison case. So he didn't get one. And what we found out of this is the Sixth Amendment extends counsel to criminal cases. Now, one thing that I also want you guys to understand, this is in criminal cases only. So if we're charged with a crime, yes, we're entitled to an attorney, but what happens if we're sued by somebody civilly? We're not necessarily entitled to an attorney, okay? So that's the important thing to understand, is that with Gideon versus Wainwright, in criminal cases, we're entitled to an attorney. But if it's a civil case, we're really not. Now, Miranda versus Arizona, Fifth Amendment, against self-incrimination. We all know the Miranda rights. We learned it from TV, movies, and we definitely know these are things we do not want to hear. Because if we're hearing the Miranda rights, what is happening? We're being arrested, right? So what the Miranda case was, Ernesto Miranda was a felon who was trying to commit a forcible rape. And when he was taken to the police station, he wasn't informed of his right to remain silent, and he confessed. Now, what this does now is it gives the government the responsibility to let us know about our Fifth Amendment rights. Okay, another case that we, which was in relation to Windsor, the case that legalized same-sex marriage at the federal level. Obergeville versus Hodges legalized same-sex marriage, but at the state level. Even though Windsor was recognized, a lot of states also had no same-sex marriage laws. So the Oberville case was consolidated with a case out of California, the Prop A case, as well as the Windsor, and this struck down all laws that prevented same-sex marriage across the U.S. The majority of the court held that the state same-sex marriage bans are a violation of the 14th Amendment due process and equal protection clause. They concluded that liberty and equality of same-sex couples were a significant burden, and that the court struck down these same-sex marriage bans for violating both of the clauses that we saw in the previous slide, holding that same-sex couples may exercise their fundamental right to marry in all 50 states on the same term and conditions as opposite-sex couples. So Windsor struck down the federal law, Obergefell versus Hodges struck down the state laws. Griswold versus Connecticut is another interesting case. Griswold was the executive director of Planned Parenthood. This happened in 1963-ish, 1964. And what Griswold did at the time was give family planning advice to a married couple. In Connecticut at that time, that was illegal, even though the couple was married, right? So what happened with this was, the question is, does the Constitution protect the rights of marital privacy against state restrictions on a couple's ability to be counseled in the use of contraceptives? What comes out of this is if we lump in the First, Third, Fourth, and Ninth Amendment, it creates what is called as a right to privacy within the Constitution. So we have a right to privacy in marital relations. Therefore, the Connecticut statute that was argued in Griswold versus Connecticut was null. This extends to Roe versus Wade, and a lot of people are more familiar with Roe versus Wade than they are with Griswold versus Connecticut, but we need to understand Griswold versus Connecticut is a landmark case that had a profound influence on Roe. Does the Constitution embrace a woman's right to terminate her pregnancy by abortion? What the court found is the court held that a woman's right to an abortion fell within the right to privacy that was established by Griswold, and therefore protected by the 14th Amendment. Now, it also gave women autonomy over the pregnancy during their first trimester, but we can have state and federal restrictions within the second and third trimester. Okay, another interesting case is Planned Parenthood versus Casey. And what happened in Planned Parenthood versus Casey, the court overturned the Roe trimester framework in favor of a viability analysis or how long a fetus can serve outside the womb, which is usually 23 weeks. This allowed states to implement restrictions that apply during the first trimester of pregnancy as well. So what the law required was an informed consent, which was a process of communication between you and your health provider that often leads to agreement or permission for care or treatment or services, a 24-hour waiting period prior to the procedure, and a minor seeking an abortion is required the consent of one parent. It basically upheld what is called the essential holdings of Roe. The essential holdings consisted of these three parts. Women have the right to choose an abortion prior to viability, and to do so without any undue interference from states. The states could restrict the abortion procedures post-viability so long as the law contained exceptions for pregnancy which endangered the woman's life or health. And the state had legitimate interests from the outset of the pregnancy in protecting the health of the woman and the life of the fetus that may become a child. So in this, the plurality asserted that the fundamental right to abortion was still grounded in the due process clause of the 14th Amendment, and that right to privacy still stuck. But then we come to Dobbs versus Jackson Women Health Organizations. Probably in the past few years, there has been states that have been putting on legal requirements with regards to abortion. A lot of them went with heartbeat laws, which could be detected as early as 6 weeks. So what Dobbs did was it overturned Roe and it overturned Casey. It gave states the leeway to determine if abortion is legal. And it ignored stare decisis or precedent, because remember, precedent was already set by Roe and Casey. The majority held that abortion was not a constitutional right, and it was not deeply rooted in the country's history, and that individual states have the authority to regulate access to abortion services. Remember in the Griswold case, we were given a right to privacy. They felt that since that right to privacy was not specifically mentioned in the Constitution, we do not have a constitutional right to privacy. It's an inferred right. So this court has taken the position that since it's not specifically stated in the Constitution, therefore we do not have a right to privacy. And remember, Roe extended that right to privacy to an abortion. Clarence Thomas, who is one of the justices, have upset many by adding this in his opinion in Dobbs versus Jackson Women Health Organization. Thomas argued that the court should go further in future cases, reconsidering other past Supreme Court cases that granted rights based off of substantive due process or that inherent right to privacy. Again, they're going to be going against precedent if they decide to do this. Griswold, which gives the right to use contraceptives. Obergefell, which gives the rights to same-sex marriage. Lawrence versus Texas, which bans laws against private sexual acts between couples. And he wrote, because any substantive due process decision is demonstrably erroneous, we have a duty to correct the error established in those precedents. So these are the different weak levels of where abortion is legal and where there are restrictions. As you can see, California is still at the fetal viability rate, but a lot of other countries have, a lot of other states have put in a little bit deeper restriction. So, this is going to continue to be a fight, and Congress can codify this and make it a law where you can provide abortions to a woman, but I'm not sure if there's enough votes in Congress to do that. All right, so just some cases that I want you all to be familiar with and to understand.
The methodology of this opinion is as important to think about as what it means in this particular application to abortion. Let's talk about the three concurrences in this opinion because they tell us a lot about the opinion, each of them. First, the Chief Justice's concurrence. He only concurred in the outcome of the case, not in any of the logic or the reasoning of the majority opinion. And what he said is, look, we don't have to do this. Today, we can just say that Mississippi's 15-week ban is constitutional, and we can leave all these bigger questions about overturning Roe v. Wade for another day. We have Brett Kavanaugh's concurrence, which says, well, women can travel to other states, which I think doesn't really appreciate how hard that is, and particularly how hard that is for poor women to pick up and go elsewhere, take out the time, take out the money, leave behind their kids. We know that more than half of the women who get abortions in the United States are already mothers. More than 50% of the people who get abortions in the United States are already mothers of 2 kids. And then, of course, there's the concurrence of Justice Thomas, which is really explosive because what it says is the logic of this opinion applies to other rights. Now, what the opinion says, the majority opinion in Dobbs, is that abortion is not protected by the Constitution because if a right is not listed in the Constitution, if it's not enumerated, then it has to be deeply rooted in our history and traditions. And we mean by that it existed at the time of the passage of the 14th Amendment. So if you step back and you say, well, that's the test for an unenumerated right, what about the right to contraception, Griswold? What about the right to same-sex intimacy? What about the right to gay marriage, Obergefell? And Justice Thomas says, yes, exactly. Let's go there. Let's take on those next. I think it's really helpful to read the dissent here, because what the dissent says is the majority wants us to think that there are only two choices. Choice number one, rights are locked in at the moment that provision of the Constitution is written in a very specific way. Or, says the dissent, the alternative is to think it's a free-for-all and everybody can just make up whatever they want if they're sitting on a court. And the dissent says that's not true. Those are not the two choices. What was that part of the Constitution at its core trying to protect? It was trying to keep the government outside of the most intimate aspects of your life. That did not mean, in the 19th century, allowing women to control their reproductive freedom, because women had a very different status at the time that the 14th Amendment was passed. They couldn't vote. They weren't considered people in the way that men were considered people, legal people with the same rights. It wouldn't make sense to get as specific as that. But if we did take that step back and we said, what does it mean to have the government out of your private spaces, then yes, there is a line between the 14th Amendment at the time it was written and the right that was recognized in Roe and again in Casey.